Welcome back to One Stop Law. Now, the landmark judgment of the Indian Supreme Court, given on 29 September 2022, have ruled that all women in India, irrespective of their marital status, will be allowed the right to safe and legal abortion, and any distinction between married and unmarried women will be seen as unconstitutional. The court has further said that the scope of law will also cover abortion in cases of marital rape, but the marital rape in this case is only limited to the ambit of the Medical Termination of Pregnancy Act. Now, I have discussed both the aspects of this landmark judgment in details in my previous two videos. I will attach their link in the description box. You can check them out. But in this video, let us understand that what the law regarding abortion in India has been, why is this ruling a big step towards female reproductive rights in India, and what will be the far-reaching impact of this judgment. Let's get started with the video. Now, the implications of this Supreme Court judgment has become more important because coincidentally, it has been delivered on the day which is celebrated as the International Safe Abortion Day, that is 29th of September. Also, the judgment has come at a time when the Supreme Court in the United States very recently has overturned the Roe versus Wade judgment on their right to privacy, a law that protected the right to abortion of US women for decades. At that time, there were several voices from India as well criticizing the US Supreme Court verdict, citing the Indian Medical Termination of Pregnancy Act and how India is ahead of the West when it comes to reproductive rights of women. These series of events in the recent times have brought into debate the Indian Medical Termination of Pregnancy Act and this latest judgment again. Now, the law in India which deals with the right of women to seek safe and legal abortion is named as the Medical Termination of Pregnancy Act. The act was enacted in the year 1971. Subsequently, it had its own rules named as the Medical Termination of Pregnancy Rules of 2003. This MTP Act and rule, however, over the years has come under serious criticism as it is far from being perfect. The systematic barriers in the Act have made abortion for pregnant persons who don't fit into the criteria cited in the law by making it more difficult. For example, take the case of unmarried women. Under the MTP Act of 1971 and its 2003 rules, unmarried women could terminate their pregnancy legally with the help of medical practitioners only up to 3 months, that is, up to 12 weeks. As per the MTP rules, only survivors of rape, minors, failure of contraceptive pills for women whose marital status changed during pregnancy, mentally ill women, or women with fatal malformation are allowed to terminate pregnancy up to 24 weeks. In cases of pregnancy due to consensual sexual relationship, termination of pregnancy is allowed only up to 20 weeks as per the 1971 MTP Act and its 2003 rules. Therefore, we see that in India too, in case any unmarried woman wanted to terminate her pregnancy, between 20 to 24 weeks with the help of registered medical practitioners, she needed the permission from the court. Now, this point where the decision regarding a pregnant woman's body by external agencies who are not impacted by the pregnancy itself has been criticized time and again by WHO also, that is World Health Organization. It has been observed by WHO in many cases that where safe and legal abortion options are not available, pregnant women tend to look for other abortion options that may not necessarily be legal and thus unsafe. As a consequence to it, most unmarried women end up resorting to unsafe abortions in illegal clinics or at home. According to the latest National Family Health Survey report of 2019 to 21, 27% of abortions were carried out by the woman herself at home in India, and also that unsafe abortion was one of the top three causes of maternal deaths in India. So, by denying the same rights under the MTP Act of 1971 and its 2003 rules to unmarried women, which married women had under the same act and rules, knowingly or unknowingly, the MTP Act furthered a social stigma that still haunts unmarried women in India. However, in its latest ruling given on this 29th of September 2022, the Supreme Court of India has taken a step forward to fix these loopholes in the abortion law by ruling that the marital status of a woman has no nexus with the objective sought to be achieved by the Medical Termination of Pregnancy Act or its rules. If this judgment is implemented, it is definitely going to empower women. The Supreme Court of India definitely went a little bit ahead to give an expansive reading of the MTP Act, and that's where it really matters. They took the intention of the law, that this law was to serve people by ensuring more and more people have access to safe and legal abortion services in India. The judgment shuts all those, hundreds of questions asked to a single unmarried or adolescent woman going for termination of their pregnancies. At the same time, the judgment also validates the marital rape and presence of sexual violence even in marital relationships, which is legally yet not considered an offense in India. So the judgment has two aspects. One is empowering women in the situation of actually being able to get an abortion without the previous hurdles which we discussed. But it has also strengthened the movement for women's rights and recognition for all these forms of violence that women in India have to face at home. The three judges of the Indian Supreme Court bench have very rightly observed, and I quote, that when the MTP Act was enacted in 1971, it was largely concerning the married women. But as societal norms and mores change, law must also adapt. Changing social mores must be borne in mind while interpreting its provisions. So societal realities indicates the need to recognize legally non-traditional family structures, and that is where the judges have gone a step ahead of validating marital rape and also giving right to equal abortion rights to both uh, married, unmarried, or single women in India. So, the societal stigma attached to a woman, which she has to face while going for an abortion in India, is about to change. At least we can hope for that change. The change may be slow, perhaps. We have to see how this judgment is taken on the ground, but it has to start somewhere. We have seen it happen earlier with Section 377 of IPC, where we saw slowly but steadily a change that people started recognizing the validity of same sex relationship on the ground level in India. So we are hopeful that in this case too, women's right to free choice of safe abortion, this judgment will give a message to the medical practitioners that women cannot be denied abortion whether they are single or unmarried, nor can they be asked these irrelevant illegal questions as to whether they are married or who's giving consent, etc. But for that, we have to ensure that it happens, for which we have to see that this judgment is given wide publicity, that it is shared with the medical fraternity so that they ensure that they implement it. Yes, it's still a long way to go, but if this judgment is implemented, it will definitely result in giving women a much better protection of their rights in India. Therefore, in conclusion, we can say that this historic judgment by the Indian Apex Court, recognizing unmarried women's right to safe and legal abortion in consensual relationship, along with its strong emphasis on women's right to bodily autonomy without the need for authorization from a third party access abortion, has been welcomed as progressive and a ray of hope at a time when sexual and reproductive rights have come under threat globally, as is evident from the recent course of events in USA. That's all for this video and this topic. We have done three extensive videos on this abortion law of India. Hope you found it informative and you got the detailed analysis of the judgment and its impact. Till I see you in some other video. Thank you all.